Hostile environment sexual harassment happens when unwelcome sexual conduct interferes with an employee's ability to work, creates a hostile, intimidating, or offensive work environment. This form of harassment can be less clear-cut than quid pro quo harassment. This is because certain types of sexual conduct can be a problem for one person, but not for another. Consider an example. Bob often tells dirty jokes in the company lounge. Bill always laughs. Jane is always offended. Is Bob's conduct sexual harassment? To decide, courts often use a reasonable person standard. This means that courts consider whether a particular type of sexual conduct would interfere with a reasonable employee's ability to do his or her job. Create a hostile, intimidating, or offensive work environment for a reasonable employee. In our example, the court would have to decide how a reasonable person would respond to Bob's dirty jokes. Note the following features of hostile environment harassment. The conduct of the harasser must be unwelcome. Harassment does not depend on gender. The harasser may be a man or a woman. The victim may be a man or a woman. The victim and the harasser do not have to be of opposite sex. The harasser can be anyone in the work environment. This includes supervisors, agents, co-workers, and non-employees, such as customers. A victim can be anyone affected by the sexual conduct. The victim does not have to be the harassed person. The victim does not have to prove any specific job-related losses. Examples of hostile environment sexual harassment could include inviting a coworker out for drinks over and over again after he or she has said no, telling dirty jokes or stories, talking about an employee's body or clothing in a sexual way, squeezing, pinching, or other physical contact, hanging dirty pictures where coworkers can see them, emailing dirty pictures or jokes to coworkers, talking about an employee, coworker, or supervisor in a sexist or sexually offensive way. Title VII is enforced by the Equal Employment Opportunity Commission, EEOC. When investigating a case, the EEOC looks at the nature of the reported incident, the circumstances of the incident, the overall context of the incident. Based on all known facts, the EEOC then makes a ruling. Rulings are made on a case-by-case basis. When an employee is found guilty of harassment, the employer may be held legally responsible. This may happen when the employer knew or should have known about the harassment, and the employer did not do anything to correct the problem. A court may decide that the employer should have known about harassment if the employer ignored prior complaints from employees. The employer did not have a written policy against sexual harassment. The harassment was open or well known within the company. In 2009, 12,696 cases of sexual harassment were filed with the EEOC. Complaints coming